Good afternoon, welcome to MEED Live. We have a very special edition of MEED Live today. We are looking at the GCC construction industry, at some of the challenges that face the industry, but more importantly, we're looking forward to how the industry is starting to respond to those challenges. And it's particularly significant today because we're launching Time for Change. This is a new report that has been produced by DLA Piper, the international law firm, together with MEED, looking at the GCC construction industry and the change that's underway in the industry and the pressures that are leading to those changes. I'm joined today by the authors of the report. So I have on my far right, I have Susanna Newbolt. Good afternoon, Susanna.
Good afternoon.
You're a partner with DLA Piper. You've nearly a decade's worth of experience
that's right.
in the GCC construction industry, and you're a particular specialist in construction disputes.
That's correct,
So
yes.
you're exactly the right person to be with us today talking about this report. And we're also joined by Colin Foreman, MEED's deputy editor, you've been at MEED for how many years now covering construction?
Since 2005.
2005, so 13 years. So we have a huge amount of knowledge about the construction industry. We have this Time for Change report, which we're going to be talking about, and we have you, the viewers. Now, Susanna, so this report, Time for Change, construction in the GCC reaches a tipping point. I'm quite intrigued by just the name of the report itself. We call it Time for Change and Tipping Point. What are we talking about? What's the tipping point we're talking about?
Well, we're all very aware of what the pressures and challenges are that the industry faces here in the GCC. And what struck us was just how long it's been the same pressures causing the same challenges, pervading the industry for the last few years. And that prompted us to carry out an investigation into it and to examine those pressures and work out what might cause change or what could cause change and what that change would look like. And actually what we found was that there are already small changes happening. And that now is the time for those small changes to tip over into significant changes for the industry.
So there are what I guess we're talking about then is pressures that have been there all the time, but circumstances in the environment, say oil prices or cutbacks in government spending, that's suddenly exposed those pressures and it's pushed the industry into this tipping point. That's what we're talking about?
I think we were looking at the same pressures seemingly having gone on now for several years and no change happening, or seemingly no change happening. But when we scratch the surface of that, there are these small incremental changes, and now is ripe for that to tip into significant changes for the industry.
Well, we're going to get into those changes for most of this broadcast, but before we do, let's talk about the research that you did and that you and Colin have done together. So you canvassed the industry, the construction companies, clients, consultants in the GCC construction industry to produce this report. What were they saying to you? What feedback or what findings did the two of you find from this research?
We got a wealth of information from the senior executives we spoke to in not just contractors and developers, but government bodies, funders, consultants as well. And the sorts of things we were hearing from them, that the pressures are resulting in, well, unsurprisingly, difficulty in developing to budget and to time, but also things that the industry has very much an environment of uncollaborative and almost adversarial relationships between the contracting parties. And we heard numerous times, didn't we, that actually that was worsened by the engineers and the PMCs in projects. And it's felt that they tend to act unreasonably and specifically solely in the interests of the employer.
So it's that classic construction thing, which the whole adversarial culture that seems to dominate construction everywhere. But is it particularly pertinent in this region?
Yes, I think so. I think because many other jurisdictions have moved on to much more collaborative ways of working. And they've also found other ways of avoiding that sort of conflict scenario. But here, we're very much still beset with that very adversarial approach.
Yeah, I think everybody we spoke to was unhappy. Everybody had difficulties achieving what they were meant to be achieving. So from a contractor's point of view, they've probably been the most vocal about problems within the sector for the longest amount of time, and those pressures still exist. It's a low margin industry, and they're taking on a lot of risk for not much reward.
Yeah.
And you throw in a sort of an economic situation where there's not much liquidity, and those pressures really come through.
So is this is basically contractors complaining, or did
No,
you speak to clients as well?
On top of that, what you also see is that we also heard, was that the developers are also having difficulties. The developers' business cases are becoming under a lot more pressure than what they used to be in the past. For various reasons. You've got real estate developers, you've got a softening property market where their businesses are operating on lower margins. They then have to secure things like funding, which we'll come on to later. So that's a pressure for them. But then on the government side as well, you've got government budgets that have been cut, you've got a lower oil price, and they really have to deliver things to the cost that they said they were going to be delivered to. They can't justify any sort of high levels of escalation in cost that they may have been able to get away with in the past. So contractors, yes, has been a long-standing issue for as long as I've been working in the region. Contractors have had difficulty. But what the other thing that's happening is that developers are finding it more difficult as well. So you've got those two things. Their viewpoint on where they stand is becoming more aligned. So I think that's why this report's so timely, really. And then in the middle, as Susanna said, you've got consultants who are sort of caught in between the two and looking after their own positions.
It was interesting, Susanna, that that was the first thing that stuck in your mind about the role of the independent engineer or project management consultant or contractor. It's that person who's responsible for enabling the contractor to get the job done, to allow variations, to sign off the variation orders. But from what you have said, it sounds like there's a view that they're basically doing the bidding of the client, and it's not an independent job. Is that what you're suggesting?
Yeah, I mean, that's exactly what we're hearing across the whole of the GCC. The biggest problem is not being paid for variations and for prolongation, so extended periods. And what's undermining that is actually not being certified, so not having variations certified and extensions of time certified. And it's very much felt that, and it's almost like a complete bar on some projects, and it's very much felt that that's the action of an engineer, it's the work of the PMCs in creating a layer of protection for the employer, and indeed a wall the employer hides behind.
Okay, now we also have, I'm just looking at the executive summary here of the report. Some of the pressures, you've got 5 pressures outlined here. So the ambitious agenda in the region, so the pressure of having to deliver the visions. We've got the tightening liquidity. So this is what you were talking about, the government cutbacks and late payments, payment delays again.
I think what Susanna said is really, really, really important. I think there's been a lot said in the region over the last few years about late payments and payments not being made. And there's a subtle difference, although from someone who's being paid, it's effectively the same thing about variation. So there's people still getting paid what they're meant to be paid on schedule. That, by and large, isn't the major problem in the market at the moment. It has been in some places for brief periods. The big problem is variations. So for the person being paid, they still feel like they're not being paid. Yeah. But then on the other side of the fence, the employer thinks, well, I have paid you. There's just work that you're claiming you've done, which I'm not convinced.
So this all comes down.
That's the reason why it's such a sensitive and difficult issue to deal with at the moment. So a lot of the time when we're talking about payment problems and people not being paid for work, from the payer's side of things, they are paying. And from the person that's being paid, they feel like they're not being paid sufficiently. So that's the source of tension that's coming through there.
What is the sentiment then? So you say that a lot of the issues highlighted in here, the pressures, have been around for a long time, but they've become more acute recently because of the changing market conditions. What's your feeling on the mood in the market? So whether it's clients or contractors, is it frustration, or we hear about people leaving the region, internationals?
Yeah, there is a great deal of frustration, and we are seeing some of that manifest itself on people being pushed so far, contractors particularly being pushed so far, that they are deciding to exit the market. And there's high levels of insolvency in the supply chain as well. So there's a real feeling that it has to change. So yes, there's frustration, and that frustration is leading to a conclusion that change isn't an option. Change is now inevitable. It has to happen.
It's time for change.
It's time for change, and you know, it's not just the contractors saying that; it's the developers saying that as well.
Okay, so what we're saying, we're at a tipping point, and that's why we've got to this report. Okay, so now the main point of the report is the changes that are underway, and if I can just summarise before we go into detail. So there are 5 key changes that you have identified in this report. I'm going to put them up on screen now. If you, Susanna, if you just want to talk through, summarise the 5 key changes that this report has identified, and then what we'll do is we'll go into the detail of the report. Susanna, do you just want to talk through briefly what these points are?
So the first change is that we expect to see greater impartiality of project management consultants and engineers. And an impact of that, of course, will be, or should be, that it unlocks the cash flow and we see fewer disputes. We're anticipating, in fact, we're already seeing a greater amount of external funding, be that within region or international. And what that will bring with it is a more sophisticated contracting environment. We're seeing an environment whereby those top-tier contractors will enjoy more attractive tendering procedures, better contract terms, and more collaborative relationships on those global standard projects. And we're also already seeing, but going to see much more, legislation aimed at increasing standards to global standards, which in itself will increase the barriers to entry for new contractor entrants into the market. And we're going to see quicker methods of dispute resolution.
Okay, so we'll take the slide down for the moment and go back to the conversation, but you've outlined the 5 changes that this report describes as happening. So you mentioned just now we're going to see them. You're talking in very certain terms. So you think they've already started, these 5 changes, and they are inevitably going to happen because they have to happen? Or are you saying they need to happen because we can't carry on the way we are?
We've identified these 5 changes because the signs are there, that small changes are happening towards these bigger changes. So in many respects, they should be inevitable, but I wouldn't suggest that we sit back and let them happen. I think it's incumbent on everybody in the industry to work together to drive towards these changes.
Okay. We've summarised the pressures that led to the report. We've explained why it's called Time for Change and the tipping point, and you've just briefly gone through the 5 key findings, the key changes that are going to shape the industry going forward. Let's pick on the first one. So the shift towards increased impartiality of the engineer or the PMC, the project management contractor. I'm going to come to you, Colin. How, Susanna has outlined earlier why this is a central issue, but how big a change would this, is this just something that's sort of gradually become a problem, or is it fundamental to the way construction works in this region?
It's been an issue for a long time, but one that's becoming increasingly apparent. There's quite a few high-profile projects where one of the key tensions on the project, which has had, in some cases, numerous issues, has been this relationship and how the consultants acted, and quite often in disputes, which, Susanna, you might be able to talk about a bit more with a bit more authority than myself. This question comes up quite significantly in disputes and the role of the engineer. So I think there's 2 ways to look at the issue. There's one actually 3 ways. There's one way to look at it is from the employer's point of view. Does the employer have an interest in this this way of doing things staying the way it is? Logic would say probably yes, because they've got a situation where they've got control over the consultant. However, I think that's a little bit short-sighted, because ultimately it can impact the delivery of the project, can cost more money, and in extreme cases, as I mentioned, can lead to project failure. So I think the employer has got vested interest for that. I think from the The consultant themselves, that's an important thing, that they don't particularly want to end up in a legal or an arbitration type situation where their professionalism is being called under question. It's bad for their reputation, and I think ultimately it's not the role that they want to be playing anyway. They're just forced into it through a sort of a contractual arrangement or a financial arrangement they have with their paymaster. And then obviously from the contractor point of view, they would undoubtedly want someone who's impartial, because that's more likely to protect their interests.
And Suzanne, sorry, carry on.
I was just going to say, I think that last point actually comes all the way around to the first. So we're saying, well, actually, you can see why the employers might not want to change the situation, but actually contractors are getting so sort of fed up with the situation that it's now influencing not just pricing risk for whoever the engineer or PMC is, but also making their decision as to whether they tender for a specific project. So they're thinking about whether to tender, not just based on who the developer is, but who their consultant team is as well. So then we've got a direct impact on the employer and a reason for the employer to want to take note and see that change.
And so are you seeing any evidence? You know, at the beginning we said these are the changes that we're beginning to see happening. Is this happening? Are we seeing some action being taken to encourage more impartiality from the PMC or the engineer?
Yeah, so I think we've already heard that at least one developer has recognised it's not in their interest and they want it to change. But actually what we are seeing is that contracts are becoming much clearer about delineating between those responsibilities of the engineer for which he acts as an agent, effectively. He acts on behalf of the employer, and properly so, and those duties in which he's carrying out a determinative capacity. So in those situations, he is required to act independently. And okay, that's not quite the end of the story, but the fact that we're seeing those that delineation incorporated into contracts now, I think, is the movement in the right direction. And actually it reflects international approach. The new FIDIC suite of contracts has gone down a similar line of better explaining and setting out those duties.
And is this as a lawyer, a construction dispute lawyer, is the role of the engineer or the PMC, the project management contractor, is that something that should be clearly defined in the contract, or is it something that should be defined in the law? Or is that difficult to answer?
Well, other jurisdictions, there are laws that require the engineer, when acting in a determinative capacity, to act independently. And we don't have that in this region at all. So we're left with having to deal with it in a contractual way.
Right.
Now, the difficulty is, of course, you can have that in your main contract between the employer and the contractor, but the engineer is not party to that contract. So the contractor has no direct recourse against the engineer for his behaviour.
Okay, so the actual definition, the definition of the role of the engineer or the impartial engineer or PMC could be in the contract between the client and the contractor, but in actual fact, there's another contract with the consultant or and the client. So there's two contracts involved.
Yeah.
And there's no
and that's
contract.
the one they're getting paid under.
Okay, so if we can just get back on screen. So these are the 5 lists. The second change that you have identified in the report is a more mature funding environment. So what do we mean by this, and in what way is this changing?
This is around seeing more external funding for projects, be that locally or internationally. And the change that brings is, on a very simple level, the bank, the funder, wants to be repaid, and they want to be repaid in a timely manner. So that automatically starts to shift the focus that we have at the moment of lowest price wins to a focus on quality and ability to deliver a project. And so what comes with that is more sensible pricing, and you're immediately looking at a certain level of expertise in the market. So it starts to level the playing field and starts to reduce the importance of the new entrants.
So lowest price wins, sorry to interrupt, but everyone talks about lowest price wins being the core problem at the root of all these construction industry problems. But how else are you supposed to judge a tender bid? I mean, you put in some quotient for safety or for innovation, or what do you do to get beyond lowest price wins?
Absolutely, and in fact, ordinarily you would expect there to be the technical bid and the commercial bid, and in fact, most cases there is a technical and a commercial bid. The problem I think we have in this region is the commercial bid takes significant priority over any technical bid.
This is for public and private sector projects, so a lot of public sector procurement rules require the lowest price bid, don't they? But private sector is different.
It can also be dealt with at the PQ stage, at the pre-qualification. So, for example, on some high-profile jobs, there's been a strong interest from the client body to make sure that things like health and safety and worker welfare are in place, and only companies that fulfil certain requirements for worker welfare are allowed to tender. Okay. And then you're running off a level playing field.
Okay, so it's possible to build in.
Yeah,
but
and the introduction of more international funding, of course we're already seeing quite a bit of international funding, means that we can expect more of that to be built in, because international funders typically are already subject to higher levels of governance. Indeed, a lot of them sign up to Equator Principles, which means there are levels of worker welfare, health and safety, environment, bribery and corruption standards that they require on the projects they fund. So, of course, that gets pushed down to the contractor. Those contractors that can't comply are out.
When you talk about international funding and a more mature funding environment, are we talking about direct or quasi-direct funding through export credit agencies, so another government or another entity underwriting its export contracts, or are we talking about international banks providing finance to, say, a PPP, public-private partnership contract, or
actually the whole range?
Okay.
So you're right, we've seen quite a bit of export funding now in this region, particularly from UK and Italy and the likes. But equally, we're also seeing now the introduction of PPPs, and so there's funding behind that. And actually, on a more basic level, there are projects where the contractor is expected to bring funds with them.
On the first point about the impartial engineer project management contractor, you said there have been signs of some developers looking to increase the impartiality. On this second point about a more mature funding environment, are we already seeing these export credit agents, the impact of international finance or PPP on?
Yes, we are. I mean, for a start, we are already seeing that funding, but we are also starting to see the impact of that on some specific projects, definitely. But I should also say we've got local funders as well that are very much alive and demanding fairer contract administration practices. And I actually saw one of your MEED interviews with Masharek Bank. Yeah. And Masharek Bank were identifying the challenges that contractors have faced in being paid and the delays in that, the knock-on effect of default down the supply chain. And they called that to be unacceptable. And they've looked at finding a solution to that problem and introduced project bank accounts. So the money's not going from funder to developer borrower, but directly into an escrow that's going to pay the contractor and so therefore flow down the supply chain.
So the banks have quite an important position in all of this.
Absolutely.
Okay.
I think on the funding side, it's related to this. I think the other thing you're seeing, particularly obviously on the real estate side, is the way that properties are being paid for now. There's the payment plans now mean that a lot of the money that a developer receives is once the project's delivered. Which should, in theory, mean that for a developer to make his profits and get the returns that he wants, he's got to deliver the project. Whereas before, if he was receiving the bulk of the money and deposits before the project was delivered, the incentive to deliver wasn't as strong. So I think that's going to drive delivery a little bit more. Yeah. It might not have such a strong emphasis on things of how it's delivered and some of the standards and things that are driven by international funding. But I think in terms of delivery and also the quality of delivery will become a bit more important. And you're seeing that already with developers now who are saying that we really have to get this thing built. We can't have a slow project on our hands.
Okay, so the shift, sorry.
so shift in priorities at the tendering stage as to who they need to do those works.
Okay, I'm going to turn to some questions. So I won't say who they're from, but and I'll just read them out. Hopefully, they make sense. So this is a question from a QS, a quantity surveying or a cost consultancy firm. Part of the contributing factor to the contractual relationship is the legal counsel who advise the employer on the forms associated with both consultancy and construction contracts. My experience in this region is that the legal counsel seems to provide advice that places all of the risk onto the contractor and also restricts the role of the PMC or the engineer. So the lawyers are getting the blame here. Is that fair? What do you think, Susanna? I think that's quite an interesting approach.
Yeah, and maybe that there is a part for lawyers to push their clients more strongly. But actually in this region we find it very difficult because clients know the market, they know what they can achieve, they know what the norm is, and that they know that they can push all the risk down to the contractor. So regardless of how we try and explain and talk about perhaps the influences and things that happen in other jurisdictions, the benefits of retaining some risk, ultimately we are only able to do what the client requires.
Do contract lawyers do that? They will say, we've seen this in the UK or in the US, or and we recommend, or
absolutely.
Those conversations happen.
Yeah, I mean, we're always talking, there's obviously a granular level when you're talking about the contracts and the approach to contracts, but there's also that sort of learning commercial aspect of, well, actually, if they're not best placed to manage the risk, perhaps you should think about taking the risk and getting financial benefits from that. But it's very difficult to change the mindsets, I think, where there's an industry norm here, and persuading clients to move away from that is difficult.
So that's why Time for Change is an important document.
I think that leads on very nicely to one of the other findings in the report about global standards and in terms of how contracts are set up and the relationship between contractor and client. I think what we've seen in the last few years is a number of high-profile projects that have moved out to tender, and they're projects that can only be delivered by international firms with cutting-edge expertise, and they've failed to get the tenders. And one of the primary reasons is contracts that are pushing all the risk onto the contractor, and the contractor's just saying, I'm not going to price that.
Isn't there a contradiction there? So we've talked in the past, and I think it was touched on earlier, with the reduced business opportunities, reduced project spending in the region. But
it's different if you're talking about pretty much run-of-the-mill work that's done in the region. That's a very different proposition to things that are absolutely never been built before and requires a global player. It's different for two reasons. One, the nature of the work requires a global player that's got the expertise, and secondly, the global player looks at the world, he doesn't look at the region. So if he's looking for opportunities, he can say, well, okay, I'm not going to work in the Middle East, but I'll pick up a job in another continent or another region. I can still get my turnover from somewhere else. It's different if you're talking about the smaller jobs or the things that aren't as technically difficult that are done by the local players, because their options are this region or this region. But when you start playing at the higher level on the bigger projects, then these things do start to creep in. And one of the things that the report talks about is, will that trickle down into the rest of the market when you start to see what the benefits are. So
okay, so we've got different industries effectively. Then you've got
the construction sector does actually sort of tier itself. I mean, a common phrase is tier 1 contractor, tier 2 contractor. That does exist, and the nature of different jobs require different expertise and different people to.
So the problems that we're talking about then, Susanna, are they more prevalent for the lower tier contractors, the sort of run-of-the-mill concrete frames, for example, compared to the higher end engineered-led structures?
Yes and no. I think that the problems are perhaps slightly different because there is a greater opportunity there with the internationals on specialist projects to perhaps gain better conditions, and in fact I think that's our change 3 nicely teed up.
I'll tell you what, hold on to the thought, and I'll just remind people of the 5 points. You've mentioned point number 3. So point number 3 on our screen here is global standard contracts for global standard projects. So
Yeah.
go back to where you were.
Right, so exactly as Colin described, I think we can expect to see on those global standard projects, those really elite projects, that the contractors carrying out those projects can enjoy more advantageous tendering processes, better contract terms, better collaborative relationships. And indeed, we've seen some examples of that already. But that is just the elite. And I think where the line blurs in terms of the pressures, and is it more of a problem for second tier rather than first tier, is that those elite contracts are getting fewer and far between.
Yeah.
And I say that not just because of the environment in terms of liquidity and all those things, but also, and Colin will have seen this far more than me, as having been in the region for longer, but there's been an upskilling of local contractors, which is pushing the sort of elite status, the technical status, further and further up.
Yeah, for sure. I mean, it's not quite the case as strongly as today as it was 10 years ago, but in terms of high-rise, for example, regional contractors had some of the best super high-rise experience in the world, you know, in terms of things that were completed in the last 4 or 5 years. So that upskilling of the regional players is a major change.
So are things have gone the wrong way then? You would have thought that doing more elite projects would trickle down that elite standards into the wider industry, but what you're describing is that as the local industry has become more competent, actually the local practices which we don't like because they create these longer term issues are coming up the way and reducing the elite levels. So actually it's not gone as we might have hoped. Is that correct?
Yeah, and I think one of the things that's happened with the market over the last 15 years is it's grown so much and got so much bigger in terms of the nature of the work that's being done and the volume of the work that's being done on an aggregate level, is that those boundaries between what was a major project and what is a sort of a fairly standard project have been completely blurred.
Can I just ask on, so we're talking here about collaboration and global standards applying to global. I know this report doesn't touch on technology so much, it's more about the contractual relationships and things, but I hear a lot about BIM, you know, building information modelling and digitalisation and big data and all of that, which seems, from what I understand, to require greater collaboration, you know, people working on cloud-based platforms or, you know, virtual twins and things like that. Have you seen any evidence from a legal point of view that that's encouraging greater collaboration and higher standards in contracts or on projects?
I think it does necessitate greater collaboration on the projects, but we're not seeing BIM used on all projects here yet.
Yeah, it's still a fairly small element.
I think the feedback in the discussions we had with people was that yes, technology can help with things, but ultimately you need to get the basics right. So obviously there's things that we've discussed already about the contract and the relationship, but then really simple things about having the right team in place, having people that are prepared to work with each other, understand each other's position, and just have a good working relationship. That seemed to be considered to be more important than technology, frankly.
Okay. So, Colin, this I think I'll put to you. Following on from the original comments about the mood in the market, do you think we are likely to see more contractors leaving this market because of the tough conditions, and will things get worse before they get better, in your opinion?
Contractors leaving the market, yes, in several different ways. I think you will see some people who are a lot more selective on work and in the past had a limited portfolio, so once they finish work will effectively leave but still have a presence and maybe tender a few bits but don't make a formal announcement saying they're leaving, and there's quite a lot of firms in that boat at the moment already. And then I think as well you'll see quite a few local organisations effectively go bankrupt or no longer really being active as well. So I expect to see quite a lot of contractors going out of the market. In the past, we've seen quite a lot of contractors coming in. That's, you know, this isn't an entirely new phenomenon that contractors leave the market, but in the past, new players have come in and taken up the slack. There are examples of new players coming in, but it's limited. You're not really seeing much coming in to sort of replenish the
Okay,
stock.
so whereas
as it
in the
were.
past it was more balanced, or we were increasing, we're
So
seeing fewer new players.
The net position is shrinking.
Okay, now we've got quite a lot of questions.
In terms of things getting worse before they get better, I think one thing and this is probably something I should have said for quite a lot of the questions, the construction industry is hugely fragmented. It's arguably probably the most fragmented sector in the whole economy. It's very difficult to make a sweeping statement saying things are going to get worse before they get better for everything. I think some clients are starting to get better already. I think
what sort of clients would those be? Would they be government clients?
It depends. It really depends. It depends if they've had a bad experience recently. It depends whether they've got a different way of funding. Depends whether they've got a specific project that they want delivering. So it really depends on.
So
on
you're nodding there, Susanna. So you're seeing the same thing.
Yeah, it made a couple of examples spring to mind actually. One of the developers that Colin and I spoke to talked to us about the experience they'd had overseas. Working in a market that wouldn't accept the sort of conditions that we have here that push everything down. So they necessarily had to take a more sophisticated approach to risk allocation, retain risk, but they had a very positive experience with it. They realised the benefits in terms of reducing the contract price by retaining some of the risk, and the relationship worked much better.
Can I ask, without naming the client, was that on the real estate side or on the roads side or transport?
That was the real estate side, yeah. And what they said is they had such a positive experience with that they've brought that model back to the UAE. So, so that's one example that made me think of. And the other was in relation to the sort of elite projects, and we've started to see the introduction of, on a very limited basis, two-stage tendering. Mm-hmm. So you've got the contractor involved at a very early stage to work collaboratively with the developer to better understand the risks, and either better allocate or better price those risks in.
Spot the problems before they get onto the building site.
Yes, yeah. So two examples that entirely speak to, I think, what Colin just explained.
Okay, now I know that any one of these points we could talk for the next hour, so I'm going to have to jump into the next question. Now this is from a lawyer, so perhaps following up on the earlier question, and I think this relates to the second point about the more mature funding environment. With the influx of funding, also a set of technical and commercial requirements from lenders in order to have balanced risk allocation, my experience in the GCC is that stakeholders are still not comfortable with the balance of risks to make projects bankable. Perhaps trying to interpret that question, I think the questioner is making the point that even the balance of risk being more evenly spread, the developer is not comfortable with that still from a commercial point of view.
Yeah, I wonder if it's saying that the banks aren't comfortable still from that point of view. So I think that there are a number of banks that are reticent and don't want to lend in this marketplace for exactly those reasons. But I think what we're going to get is a situation where, because the external funding is required, that there's going to be a shift in that risk allocation to accommodate what the funders want. So very much do think it's going to end up being driven by the funders.
We'll move on to the next bullet point and then we'll try and get the questions. So looking at the screen here, bullet point number 4, game-changing legislation, increasing standards and barriers to entry. So one of the pressures that you mentioned at the beginning was the barriers to entry, low barriers to entry. Yeah. So what do we mean about this game-changing legislation?
What we mean is that we're going to see, I think, more legislation coming in to increase standards. And when I'm talking about standards, I'm talking about those things like the worker welfare, health and safety, bribery and corruption, modern slavery, all these things.
So this is not technical standards, this is the sort of environment, the work environment.
Yeah, absolutely. And we've seen a great deal of progress over the last few years in terms of legislation coming in that regard. And I think that's been necessary because of the media and human rights interests in the region. And that was renewed, I think, by projects like the World Cup in Qatar in 2022 and the Louvre project in Abu Dhabi. They suddenly gained a sort of re-interest of media and human rights group interest. Now, the longer and the more this region wants to be on that global stage, and we know it does, the more pressure is going to come to increase this legislation. We've seen examples of it happening. Minimum wages in Bahrain, worker welfare and funds for workers in Qatar. We've seen not legislation, but the anti-corruption drive in Saudi. And so I'm confident that with that pressure, we're going to see more and more of this legislation coming in.
Is your feeling, Colin, that those changes that Susanna has just outlined, that's because of greater international scrutiny, or is it because workers and suppliers expect it? Or, you know, what?
Yeah, and I think there's also another level to think about. You know, when things do go drastically wrong, and there are a large number of workers that are left unpaid, and you know there are some pretty horrific examples that go out. It's ultimately the government that has to step in to sort it out. So it's in the government's interest really to put legislation in place to make sure those people are protected, so they don't have to step in and take care of things. So yeah, I think that's something that will move in the right direction, and in fairness has moved, as Susanna said, has moved an awful lot over the last few years and is continuing to move.
And presumably Expo, you didn't mention Expo in your summary, presumably also the scrutiny or the attention that Expo 2020 will bring to the UAE and to Dubai is another factor.
Yes, and every world event that the region wants to host going forward. But I think an important sort of progression from that point of introducing the legislation is that at the moment we've got contractors coming in internationally that are already necessarily complying with these sort of global standards, whereas a huge gulf between those and those sort of local and new entrants to the markets that haven't previously been subject to that. So once there's more legislation, it becomes a more level playing field because all contractors have got to incur those costs.
Okay, I've got a long list of questions, but the top two that I see on here are about adjudication, and I know that's point number 5, so I'm going to go to the final bullet point. These 5 bullet points are the changes that we're beginning to see coming out of the pressures on the industry and that we expect to see going forward. And so number 5 is quicker methods of dispute resolution. So what are we seeing at the moment in terms of speeding up dispute resolution, and where will it go?
I'm going to deal with where will it go first, because one contractor said to us, adjudication would sort it out overnight. But it's not just the contractor that were saying that. We actually heard from developers talking about adjudication as well. Adjudication being a swift method of dispute resolution, the idea being that you get a decision from an adjudicator within 28 days of referring a dispute. That decision is then binding. The parties have to carry out whatever the decision is there and then. But if sufficiently disgruntled with the decision, they can have the same issue heard in their usual forum for dispute resolution, be it arbitration or court later. So that is where we might end up. And I'm couching that a bit carefully because there are significant challenges to introducing adjudication into this region. Steps have been taken before, albeit they didn't come to fruition in Qatar. But I believe steps will be taken again. And part of the reason for my belief in that is that Dubai has actually set up an ideal environment for it. The DIFC, much more integrated with onshore Dubai.
So DIFC, that's Dubai International Financial Centre.
Absolutely, yeah. And the DIFC courts have got a lot of confidence now in their enforcement of their own court awards and court judgments and arbitration awards. And which has gained, so they've got a lot of confidence from the region. But they also introduced a year ago a construction and technology division to that court, and that's presided over by a former English judge. So what we've got is a specialist court that understands the concepts and the benefits of an adjudication process. So we actually now have an ideal platform to introduce adjudication into the region.
So, so you're talking about a specialist court in the DIFC, the Dubai International Financial Centre. What jurisdiction does that have in regional terms? Does that just cover the Dubai market, or is it the decisions of that court are the UAE wide, or what's the jurisdiction?
Well, in terms of who can avail themselves of those courts, it's open to anybody to opt in to DIFC as jurisdictions for the disputes to be heard. And we often do see Saudi, even Qatar and other places that have included as their forum for dispute resolution, DIFC.
Okay. And
So
adjudication is, if I can just clarify for anyone who doesn't follow this, so this is where two parties have a dispute and they bring in an outside expert, a third-party independent expert who has perhaps some technical background, or who will, within 28 days or a certain narrow time frame, give an independent judgment. And that then is a binding agreement between the two parties.
That's then a binding, that decision is then binding on them. So they must take the steps required by that decision there and then at that time, yes. But the crucial thing, and the thing that makes it more difficult to introduce it into onshore environment in this region, is that it's not final. So if really upset by the decision, you can go and have the same matter heard by your court or arbitration later. But it is worth saying that I don't know the current statistics, but it's something like 95% of adjudications in the UK never get reopened in a court or arbitration, because it's about moving cash flow, it's about getting that something that people can live with, however rough and ready at the process, and the project moves on.
So in the UK in the late 1990s, as I understand it, a lot of the pressures that you have described in this market were being experienced in the UK, and the whole construction industry in the UK went through a sort of change program which brought in adjudication.
Absolutely.
There. What difference did it bring to the UK construction market? I mean, is it quite was it a step change in the way things happened?
Yes, it was, and because it was a statutory right in the UK, it would mean that regardless of any contract conditions, if you had a construction contract, you can refer that to a dispute to adjudication, which meant it unlocked any cash flow problems.
Right.
And the idea was it did exactly that. It would unlock cash flow problems, enable projects to continue, and start to reduce the insolvency down the supply chain that was being achieved by these sort of paid when paid positions and money not flowing down the chain.
Okay. Now we've got about 7 minutes left, and we've got a long list of questions. I'm going to rattle through them. Can either of you just step in when you think that you're the best person to ask? So this first one is about adjudication. It is from a lawyer. So how likely is it that the GCC will adopt a payment adjudication system in the next 5 years? So this kind of, you've said the change is there. What do you reckon? And it says GCC, which is obviously not a single jurisdiction, it's multiple markets, but how likely?
As I've said, we've actually got the ideal environment for it now. I think it's certainly possible within the next 5 years. I'm going to be optimistic and say perhaps at the far ends of that 5 years we might see the introduction. But I would just say we're going to see, I think, other quick methods of dispute resolution coming in before that.
What would they be?
That was your initial question,
yes.
Which I avoided at the outset. So, well, there are other ways that people are looking at finding quick methods of dispute resolution. And a great example, and one that's just at the front of my mind at the moment, is the RICS administered.
So that's the Royal Institute of Chartered Surveyors from the UK, but
thank you. Yes. In the Middle East, are bringing in or have a process that they administer called a conflict avoidance process. And they're doing that in conjunction with DIFC. And it's effectively going to be a method of having an issue resolved by the relevant technical expert at the time before it actually turns into a formal dispute. So I think we'll see these alternative I'm calling them softer because they're not so formal dispute
prevention
methods,
rather than resolution.
coming in a lot sooner.
Okay.
I know the RICS are talking to interested developers at the moment about it and about incorporating it into contracts, and I hope that they'll be in a position to launch that before too long.
Colin, any thoughts on if and when we might see adjudication in the GCC?
I think it will be towards the back end of 5 years, but I think there will be, I think there already are smaller changes coming through to try and unlock the position, because ultimately there's quite a lot of projects out there that are stuck in effectively a stalemate position, and people just want some decisions made and things to get sorted.
We have a second question here about adjudication. It's, I think we've probably answered it. Do you think it's time for the government to introduce adjudication-style dispute resolution? So I think we've probably dealt with that. This is from a contract and claims manager. Management of risk is a big problem, and as we've said, understanding and having risk managed best by those who are qualified to do this in a no-blame culture is important. From the discussions with employers, is there any understanding that they are in some ways responsible when things go wrong? So, in your experience dealing with the clients, the employers, are they aware that when things go wrong, it's not always the contractor's fault, it's sometimes their fault? And I'm paraphrasing from the questioner here. What do you think?
I think there's starting to be a greater understanding that things, and the example I gave about the developer having had the positive experience about the different risk allocation. So I think there is starting to be an understanding that there is a greater impact. But unfortunately, I think in many respects there's still sheltered or by the sort of curtain of PMCs and engineers. So that if the employer's not hearing and not understanding the true situation, then they're not necessarily going to understand that they're partially to blame. I don't know, Colin, if you've got any views on that.
I think it works the other way. Contractors tend not to say they got things wrong on a job. It's always someone else. So I think that's one of the main things that.
I mean, I guess that's a natural product of an adversarial culture.
Yeah.
You can't admit liability because it leads to costs.
Which is why something like someone impartial and external coming in and saying, look, let's look at this and try and come up with a conclusion that, okay, might not be perfect, but at least we can move on, is so important.
Would you say, so this is coming from a cost consultant, would you say that the lack of clear procurement regulations and biased construction contracts are the main problem? The lack of adjudication laws are not helping the weaker link in the construction dispute. I think this is points as well as questions. So do you agree that the lack of clear procurement regulations is the main problem? So that's the first point. Log that one in your minds. The lack of adjudication law is not helping the weaker link in the construction dispute, so that's the point about adjudications. The lack of published local judgments is not helping legal advice, and FIDIC does not have reference for project managers, and also a lack of standard methods for measurements. There's quite a lot of points there. Do you want to come in?
Shall I tackle procurement?
Go for it.
Procurement, yes, you could say that for government work, but a huge amount of work in the market is private sector, which they can award contracts and however they want to.
Okay, Susanna?
It sounds like a good list of all the things that are contributing to the, can I say, less successful environments we have at the moment. And I would say all of those things are applicable. Can you just remind me of what was right at the bottom?
So right at the bottom of the list, there's a couple of points about FIDIC contracts. So adopting FIDIC contracts with numerous amendments kills its purpose. So it's about amendments. And then the second part of the question was, FIDIC does not have a reference for project managers, and also there's a lack of standard methods of measurement. So I don't know enough if those are three separate points or if they're interconnected.
Well, I'll deal with the first one because I feel quite strongly about this as well. With all standard forms, they're designed to be balanced, and they're between the parties signing up to them. The moment that you start amending that, you defeat the purpose and the underlying principles with that. So absolutely, once you start amending FIDIC, you start introducing the problems that we see very much in this region.
Okay, now I've just noticed that we're now over time, so I'm going to have to bring the broadcast to an end. Thank you so much for your comments. Just to remind you, these points you can see on your screen, these are the 5 changes that DLA Piper and MEED have concluded we're starting to see happening in the GCC construction industry as a result of the pressures that we're all facing. The increased need for impartial project management consultants and engineers, a more mature funding environment, higher standards for contracts and for projects, new legislation to improve the working environment in construction, and quicker methods for dispute resolution. So these are the points highlighted in this report, Time for Change. You can download the report from the screen in front of you using the Resources tab, or it's going to be on the DLA Piper website as well. I think there will be a link which we can circulate.
Absolutely.
So that is why we're talking today. We're out of time, so thank you very much.
Thank you.
Susanna Newbolt, partner at DLA Piper, Colin Foreman, deputy editor of MEED, and thank you to you for joining us today. See you next time.